My name is Marcus Bell, and 11 months ago I did something I thought was completely reasonable. I installed solar panels on my own roof to cut my electric bill in half. What I didn't expect was for my homeowners association to declare war on me over it, fine me $200 a day, and threaten to put a lien on my house. If this is your first time here, welcome. If you've watched my other stories, you already know the pattern. Someone on a board decides their opinion outweighs the law. This one, though, has a legal twist that even surprised my own attorney. Stick with me, because by the end of this story, the HOA board that fined me ended up owing me money instead. Let's go back to where it started. I bought my house in Willow Creek Estates 2 years ago. Nice neighborhood, good schools nearby, friendly enough people. Like most new homeowners, I didn't read every single page of the HOA covenants. I skimmed the important parts about paint colors and lawn maintenance and figured the rest was boilerplate. That turned out to be a mistake I'd pay for later, though maybe not in the way you'd expect. Last spring, my electric bill hit $340 for the month. That was the breaking point. I'd been putting off getting solar quotes for over a year, mostly because of the upfront cost, but with rates climbing every quarter, the math finally made sense. I got 3 quotes, picked a reputable local installer, and signed the contract in April. I did check the HOA guidelines before signing anything. I wasn't trying to sneak anything past anyone. The covenants had a section on roof modifications that required board approval for anything visible from the street, which solar panels obviously would be. So I submitted a formal request with the installer's spec sheet, panel placement diagram, and a rendering of what the house would look like afterward. 3 weeks later, I got a letter back. Denied. The reason given: solar panels are inconsistent with the aesthetic character of Willow Creek Estates and are not a permitted roof modification under Article 7 of the Community Covenants. I called the HOA office the next day and spoke with the board president, a man named Richard Kowalski. He was polite enough on the phone, but firm. Marcus, I understand the appeal of saving money, but our community has maintained a specific look for over 20 years. Solar panels weren't part of that vision when the covenants were written, and the board unanimously agreed they don't fit. With respect, I said, I did some research before calling, and I believe state law actually protects homeowners' rights to install solar panels regardless of HOA aesthetic preferences. There was a pause. I'd have to check with our attorney on that, but our covenants are legally binding, Marcus. I'd encourage you to reconsider before doing anything the board hasn't approved. I hung up feeling like I'd just been politely threatened. But I wasn't about to let a fear-based scare tactic stop me from doing something I was fairly confident was legal. So I decided to actually confirm it before moving forward. I spent that whole weekend digging through my state statutes. And there it was, plain as day. My state had passed what's commonly called a Solar Rights Act back in 2015. The law explicitly prohibits HOAs from banning solar panel installations outright. It allows associations to impose reasonable restrictions on placement, for example, requiring panels to be installed in a less visible location if a technically equivalent spot exists without meaningfully increasing cost or reducing efficiency. But a flat denial based purely on aesthetics? That was exactly the kind of blanket prohibition the law was written to prevent. I printed the statute, highlighted the relevant sections, and mailed a follow-up letter to the HOA board along with my original application, formally requesting they reconsider under the applicable state law. I fully expected this to resolve things. It didn't. 2 weeks passed without a response. So, believing I had a strong legal basis and a right that couldn't legally be denied, I moved forward and had the panels installed. The crew was in and out in a single day, 22 sleek black panels across the south-facing side of my roof, barely visible unless you were standing directly in my driveway looking up. 4 days later, I got a violation notice taped to my door. Unauthorized roof modification, solar panels installed without board approval. Fine, $200 per day until removed, effective immediately, retroactive to date of installation. I stood there doing the math in my head. 4 days already meant $800, and it was climbing by the day. This wasn't a warning anymore, this was an aggressive financial attack against someone who'd followed the actual law. I called Richard immediately. His tone had changed completely from our first conversation, sharper, more defensive. "You were told the application was denied, Marcus. Installing anyway was your choice. The fines will continue to accrue until the panels are removed, per our covenants. I sent you the Solar Rights Act statute 2 weeks ago," I said. "Did the board's attorney review it?" "Our attorney is aware of your claims. The board's position hasn't changed." That single phrase, "your claims," told me everything. They weren't planning to engage with the actual law. They were betting I'd get scared off by mounting fines before I ever got a lawyer involved. A lot of people in that situation would have. I almost did too, if I'm being honest. Watching $200 pile up every single day is genuinely stressful, no matter how confident you are that you're in the right. But I'd already done my homework, and I wasn't going to let a bluff win. I hired an attorney named Sandra Ellery, who specialized in HOA and property disputes, specifically because her practice page mentioned solar rights cases. I sent her everything: my original application, the denial letter, the statute I'd cited, and the daily fine notices, which were now arriving weekly with updated totals. Sandra called me back within 3 days, and I could hear something almost like amusement in her voice. "Marcus, this is about as textbook a Solar Rights Act violation as I've encountered. Flat aesthetic denial, no consideration of alternative placement, fines imposed specifically for exercising a legally protected right. This isn't just a strong case. Depending on how your state statute is structured, they may have opened themselves up to statutory penalties on top of everything else." "Statutory penalties?" I asked. "Some states with strong solar rights acts allow homeowners to recover attorneys' fees, and in certain cases, additional damages, when an HOA violates the statute in bad faith, meaning they were made aware of the law and continued violating it anyway." "You sent them the statute directly?" "That's about as clear an example of bad faith as you can document." Sandra drafted a formal cease and desist letter to the HOA board, citing the Solar Rights Act by section number, documenting that they'd been formally notified of the statute before continuing to impose fines, and demanding immediate cessation of all fines along with a full refund of every dollar already charged. I expected the board to back down once a lawyer's letterhead was involved. Instead, Richard doubled down publicly. At the next HOA meeting, which I attended specifically to see how they'd respond, he stood in front of about 20 residents and said, "Some homeowners believe they can install whatever they want and hide behind out-of-context legal claims. The board will continue enforcing our covenants as written, regardless of any letters we receive." A few people in the room actually clapped. I sat there thinking about how much stronger my case had just gotten, because now there were 20 witnesses to the board publicly restating their intent to keep violating a state statute they'd been formally notified about. The fines kept accruing. By the time Sandra filed the formal lawsuit 2 months later, the total had climbed past $12,000. Sandra's complaint cited the Solar Rights Act violation, requested a court order voiding all fines, a full refund with interest, and, because of the documented bad faith after formal notice, a request for the HOA to cover our attorney's fees under the statute's fee-shifting provision. During discovery, Sandra's request for records turned up something neither of us expected. Willow Creek Estate's own covenants had actually been quietly updated 4 years earlier by a previous board to include a solar-specific placement clause, almost word-for-word matching language recommended by the state's own model HOA guidance following the Solar Rights Act's passage. In other words, a prior board had already done the right thing and built in a compliant process. The current board either didn't know that clause existed or chose to ignore it entirely when they issued a blanket denial instead of evaluating my actual placement request under it. Sandra brought this up directly in a filing. Not only had the board violated state law, they'd violated their own community's updated covenants, the one specifically designed to keep the association in compliance. This wasn't a case of an outdated rulebook nobody had thought to fix. Someone had fixed it, and the current board either ignored the fix or never bothered to check before denying my application. At the hearing, the HOA's attorney tried to argue that the board's aesthetic discretion under Article 7 still applied broadly. The judge asked him directly whether the board had ever evaluated an alternative panel placement before issuing the denial, as required both by the statute and by the association's own updated covenants. The statute is clear, the judge said. An association cannot deny a solar installation outright based on aesthetics alone when a compliant placement process exists, whether through state law or the association's own governing documents. This board did neither. The fines imposed were unlawful from the date of the first notice. The ruling ordered full reversal of every fine, by that point totaling just over $14,000, since the board had kept adding fines even after the lawsuit was filed, plus interest, plus, because of the documented bad faith after formal legal notice, an order for the HOA to cover the entirety of Sandra's attorney's fees. The financial impact on the HOA was bigger than just my case. Once the ruling became part of the public record, 2 other homeowners in Willow Creek who'd quietly abandoned their own solar plans years earlier after informal pushback from the board came forward. One of them had specifically been told by Richard, verbally, that solar wasn't allowed, despite the compliant placement clause sitting in the covenants the entire time. The HOA's insurance ended up covering part of the judgment, but the special assessment the board had to levy on the whole community to cover the rest did not go over well at the next meeting. Several residents who'd clapped for Richard's defiant speech a few months earlier were considerably quieter this time around. Richard resigned from the board less than a month after the ruling. I heard through neighbors that it wasn't entirely voluntary. Several residents had started organizing a recall petition once they realized how much unnecessary legal exposure his refusal to even evaluate the compliant clause had cost the entire community, not just me. The new board's first official action was updating the HOA's solar application process to explicitly reference both the State Solar Rights Act and the existing placement clause, with a required review checklist so no future board could simply issue a blanket denial without documenting why a compliant alternative wasn't available. My panels are still up, obviously, quietly generating power every single day since the installation. My electric bill most months now runs under $40. Looking back, the thing that sticks with me isn't even the money we recovered, though obviously getting $14,000 in unlawful fines reversed felt incredible. It's how close this came to going the other way, simply because most people assume an HOA board speaking confidently must actually be right. They aren't always right. Sometimes they're just betting that you won't check the SO. If there's one thing I hope you take from this story, it's this: before you let a denial letter or a daily fine convince you that you're in the wrong, check your actual state law. A lot of states now have some form of solar rights protection, and plenty of HOAs count on residents never reading past the covenant packet they were handed at closing. That's my story. If you've ever had an HOA try to block something you were legally entitled to do, tell me about it in the comments below. And if this one got your blood boiling in a satisfying way, subscribe. We've got new HOA stories every week, and some of what's coming is even more unbelievable than this. Thanks for watching. I'll see you in the next one.